directors.
You're all ready?
Okay, thanks everyone for showing up for our first directors forum here at the Church Review Research Park building. Today we have a guest speaker from Barnes and Thornburg that's going to talk about the subject of playing the patent game. She is a native of Indianapolis, Indiana. Went to school at Florida Southern College. I think there was a strategy there to go to a warmer climate based on good intelligence. After graduating from Florida Southern, she went to IU Bloomington and got a Master's of Arts in German Literature. And after a stint at IU, she went to Rutgers University Law School and got a law degree. And thereafter, she clerked for Justice Theodore Bohm and retired Justice Myra Selby, both of the Indiana Supreme Court. After that, she joined Barnes and Thornburg, one of our premier law firms in Indianapolis, and she concentrates on IP litigation, commercial litigation, antitrust matters, and appellate matters. Please help me welcome Deborah Pollock Milgate. And before she starts, for the remote locations, it will go for about 45 minutes, the presentation. And if you have any questions, press the remote on your table and wait for the red light to come on, wait until it turns green, and then ask your question. Deborah, thank you.
Thanks. Thank you so much for having me. I didn't realize this was the first one of those here, and so I feel honored to be here today. If you aren't very familiar with lawyers typically begin a lot of their talks with caveats, so I thought I would just begin with a couple of caveats for today's presentation before we move on. First caveat is that I was sort of under the impression that we would have a very different skill set and knowledge set that would be coming into this room today. And so I hope that at least at one point today I will talk over someone's head. I hope at least at one point today I will also talk down to someone else, and hopefully then somewhere in the middle I will have achieved the right balance. So that's caveat number one. Caveat number two is that really what I'm covering today is so broad, and each one of my slides could almost be the separate a topic for discussion in and of itself, that really all I hope for you to come away with today is just, if you're going to be in this field, if you have technology, you have to sort of have the overall lay of the land of all of the things that you need to think about to be able to protect your technology and also make sure that you're not running afoul of other people's technology. So that's, broad brush, that's the goal today. And then I did also hear something about some rumor about this being on YouTube, but all it is giving a shout out, like a Sarah Palin type shout out to my family or kids or something. All right, with that, okay, so playing the patent law game requires offense and defense. And really what I mean by offense and defense is sort of what I alluded to already. Offense referring to, that's your technology. You may decide to patent it, you may decide to have a trade secret, but I want to roughly outline for you from an offensive perspective, how do you get the best patent if that's what you're trying to do? How do you protect yourself? How do you protect your technology? But at the same time, it's very important, obviously, that you can play defense because even if you, let's just say there are certain people who are frankly so afraid of patents that they don't even want to play offense, that doesn't get you off the hook. Even if you don't play offense, if you have technology, you have to play defense. So defense is obviously then going to focus on the intellectual property rights, specifically patent rights of others. So here's the things we're going to look at today. Here's our offense. First, we're going to talk about the rights that are conveyed by a patent. I hope that doesn't bore you to tears. I'll keep it short, but I want to reiterate a couple of points that I think people mess up a lot and really need to understand. Then I want to talk about patents versus trade secrets, some of the things you might want to take into consideration in determining whether you would like to patent your technology or whether a trade secret is perhaps the better way to go. Then I want to talk about what you do, how you And also then, just generally speaking, how you protect your technology, usually from the perspective of a company protecting its technology. Then we'll talk about litigation, if it comes to that. And then lastly, this is just going to be a footnote, but I'd be remiss if I didn't mention the issue of patent marking at the same time. Then with respect to defense, I have only 3 areas with defense, but that shouldn't tell you that these are any less important because they really are every bit as important. I'll talk about freedom to operate, what that means, what the limitations are, and how you get your best freedom to operate analysis. If you find that there's an issue that you have to deal with, we'll talk about how you address the concerns that you have with the competition or with other patents out there. And then finally, we'll talk also about litigation from the defensive perspective. Okay, so I'm going to try to take you through these 3 slides fairly quickly. You probably have seen this before, but here are the requirements for patentability. Generally speaking, we've got 35 as Title 35 of the United States Code, sections 101 through 103. These are probably the requirements that you've heard about before. Something has to be new, useful. I guess new and novel, I'm not quite sure why they're there twice, but they are. Useful, novel, and non-obvious. The elements of the patent you've probably seen as well. Here's the patent for scissors that you have in front of you. I'm not the only one who does this. For whatever reason, scissors are a really good means to talking about a patent because you can sort of add on and take off, and they're very helpful for illustrating patent concepts. I was sort of amazed when I looked for patents, how many scissor patents there still are.
Yeah.
So I chose a scissor patent for you. There's the filing data and the issue date, which you can find on the front page. You've probably looked at that before. You probably know what the patent terms are, so I won't talk about that. Then you've got the abstract on the title page as well, which will tell you, roughly speaking, what the invention is about. And then obviously you have some drawings as well. Here what we have is the claims, and you can find this at the very back of your patent in front of you at column 4. It's actually the 3rd to last page back there. And in case you haven't learned this, the only thing that really matters at the end of the day, that's not completely true. The most important thing about a patent at the end of the day is the claims. A lot of people, when they read patents, make the mistake of paying a lot of attention to the written description, to the specification, to the text, because it's nice and it's easy to read. But at the end of the day, the invention that you have is what is claimed at the last part of the patent, the numbered claims, which talk about the invention. And as part of that, you have a couple of different elements. You have, first of all, a pair of scissors for cutting stiff, sheet-like material comprising, that's called the preamble. It's actually not really part of the claim for purposes of determining, on the other hand, whether someone actually is using your claim, is using your invention. And then you have the elements, what are called the elements of the claim. Here we have 2 elements. We have a first scissor member having a blade, wherein the blade has a substantially linear, sharpened edge. And for these purposes, I actually brought a pair of scissors. So far, it looks like we've got the first element met. I've got a pair of, this is the special scissors you get when you work for Barnes & Thornburg. So we've got the first scissor member having a blade, wherein the blade has a substantially linear, sharpened edge. Looks good to me. A second scissor member pivotally connected to the first scissor member. All right, I think if we stopped there, we probably would have the elements of that claim. Luckily, it goes on. The second scissor member having a sharp claw near its distal end, wherein the shape of the claw is defined by an arcuate recess formed in the second scissor member, and so on and so forth. So I mention this because really, if you think about these scissors right here, we've got the first scissor member having a blade. We've got something pivotally connected. And so if you think about in terms of what makes this very beautiful scissor claim actually patentable, it's got to be in the area that follows that second portion portion which tells you how is this different from everything that you've seen before. Now this may all make a lot of sense. You may have been through this before, but I'm going to come back to it because it's important for a couple of other things we're going to talk about today. And then the other two parts of the patent, just briefly, the specification and the prosecution history. The specification really being everything that's written, all of the text that's in the patent, and then the prosecution history, which is going to be the back and forth between the patent office, where you told the patent office what your invention is about. Again, I mention these because when we start talking about an infringement, the claims, the specification, the prosecution history are going to be very important things for us to talk about and remember. All right, so here's our offense. Let's jump into it. First of all, rights conveyed by patent. If you don't remember anything else today, and I'm sure you've heard this before because lawyers say this all the time, but it gets overlooked again and again and again. The only right you get from a patent is the right to exclude. So what does that mean? Does that mean if you have a patent that you have so-called freedom to operate? Absolutely not. A patent doesn't give you the right affirmatively to do anything. It only gives you the right to exclude others. I can't tell you how many times I've heard fairly sophisticated people say, but I have a patent. It's mine, I patented it, therefore I have to be able to use it. No, it absolutely can't happen. So let's take the scissors example again. If you think back to our scissors claim and you picture a pair of bizarre looking scissors, sorry, I'm glad it's not your patent because otherwise I would have probably just insulted it. But we have a bizarre looking pair of scissors, right, on the first page of this. Let's just assume for a moment that the patent to this pair of scissors still exists out there. If I practice this patent, I might very well also practice this patent at the same time. So I could have the right to do this, or the right to exclude others from doing that. See, I almost did it too. The right to exclude others from doing that. But if there's still a patent out there on this pair of scissors may infringe the patent to this pair of scissors. Does that all sort of make sense? Okay, important point again, it happens all the time. So, and as we've talked about before, the patent claims define the rights. So there's a lot of nice information in the specification, it's very important, but the patent claims define the rights, the boundaries of what it is, the property you have where you say no one else can come onto it. Okay, procuring your best patent. So here's some things that are important to think about in getting the best patent you can possibly get. First of all, a documented invention is a really, really good thing. Make sure you have good notebooks. Make sure you have good invention disclosures. I really can't think of an instance in which there's been too much information about an invention. This is really an important thing. It's easy to overlook. Please take care of it. Second one, landscaping analysis. This can be a very, very valuable tool. And what this really does is you sort of have someone, preferably an attorney, take a look at everything that's already out there, roughly in the same area that you're operating in, and have that person then talk to you about what areas still need to be filled in that are related to what you are doing. Now, sometimes you just do, you create, you invent, and you don't go through that process. But the landscaping analysis can really make the research much more targeted. It also may identify the fact that you thought there was something that you had invented, and it turns out someone else has already had the same thinking that you did. And then it turns on a little bit of, you've got patentability issues as well. But in any case, this is a really important tool for really taking a look at what everyone else is doing, which is always a pretty good thing to understand. And then think about how you can tailor your research and your activities toward the gaps that still exist. Broad versus narrow claims. It's also important that in the patent process that you try to obtain the broadest claims that you can without going completely crazy. And the reason for this is follows. The narrow claims are often, sometimes they work really well because sometimes that narrow claim is exactly what you invented. It's really important and everyone else would want to do it. So that's fine. The problem that happens sometimes is that narrow claims are easy to get around. So I remember a patent I saw at one time, and I won't talk about it in any detail, but it had a bait system. And part of the actually for the bait system to be cylindrical. Well, okay, probably patentable. There was probably some minute advantage to it being cylindrical. There were a lot of other elements to that claim as well. But at the end of the day, what do? Well, I'll just make a spear. I mean, it's not that hard. So this goes back to where I started with, which was procuring your best patent. It's not enough to get a patent. If your patent is someone that anybody can design around, if you've claimed the shape of something, if you've claimed the color of something, and these are just obviously very, very rough examples, it doesn't matter that you have a patent. And people sometimes get really, everybody's really enamored with the idea, I have a patent. Well, you also want it to be worth something. Another thing that's important is that, best case, you would also want claims that actually cover your product, if you have a product. There are many reasons for this. One is just that, it's sort of hard to talk about how great your invention is if your own product doesn't cover it. And that can come into play in many different cases. Infringement is one of them. Also be involved in the process of looking at the patent as it goes through the prosecution. And there are a number of reasons for this. And this also holds true, by the way, for something like landscaping analyses as well. Oftentimes, what you start with looks very different from what ends up to be that patent. And if you're not involved in that process, you might end up with a patent that, okay, we'll go back to the fourth bullet point, doesn't cover your product, but also isn't really what you thought you invented. So make sure that you're involved in that process and that you get exactly what it is you want. All right, patents versus trade secrets. You can read, again, as I said, you can read on this issue for days and days. There's lots of information out there. You can find a lot of it online, too. Before you actually decide to patent your invention, again, not being too enamored by the patent concept, think about, are there other ways? Is the invention going to give me the protection I want? So let's talk about the trade secrets. If your technology can be reverse engineered, patent is probably a pretty good thing because there's no way to keep it trade secret. So if what you have can be reverse engineered, this is almost a no-brainer. Length of protection desired. We all know Coca-Cola is probably pretty happy that it has a trade secret, not a patent on the formula to Coke. It's a good example. If you want protection for all time and you really think you can protect it, have the safeguards in place to protect it, then that's another reason why you might want to have a trade secret instead of a patent. Other thing is an ability to police. If you have a patent, and this comes up, I think, most often in process patents, if there's a process that then goes into an end product, and you can't really tell what the process was, that means your competitor can come out with a product, and you have no way of knowing whether they've actually used your process or not. In other words, if you have a really hard time detecting infringement by one of your competitors, if you have no way of knowing that your patent is going to be infringed, you might want to think about either trying to come up with different claims, or perhaps a trade secret is a better way to go. Here's some other protections you might want to think about in terms of protecting your technology. And here are a couple of instances, one you may be rather familiar with, in which things can get a little murky with respect to property, intellectual property and patents, and where disputes are often born. One of them is with respect to joint development. Lots of businesses do business this way, and it's important. But when you jointly develop something, you do end up having some issues with respect to joint inventorship. You have an issue of what belongs to whom. This is something that, if you are in that sort of arrangement, you need to think pretty hard about protecting your stake in the intellectual property that's created in the relationship. And then I'm just going to skip down to the nomadic employees. These people who sort of go from one company to the other and to the other. As it turns out, people tend to blab. I know that might be shocking to you, but it happens. You need to really make sure that, to the extent that you can, you have the protection in place from those employees and a way to follow up to figure out, ensure that they don't blab. And quite frankly, it's pretty hard to do. But as a minimum, we do have confidentiality agreements and things like that to make sure that, to the extent you can, you have people sign the agreements. People are aware that there are protections in place. And in some cases, the confidentiality really is going to apply more to trade secret rather than patents. But still going to apply. And the other thing that comes up with nomadic employees is what they do is they take something with it, and you haven't patented yet, and then it shows up in another patent of your competitor, and then you go, oh my gosh, how did that get there? Well, not that hard to figure out. Okay, let's talk about litigation. Potential claims in federal court. We're always in federal court here, which is a good thing. Federal courts tend to be pretty good. If you find out that someone is infringing, you can bring a claim, and the most frequent claim you would bring is just something, it's just pretty straightforward. It's called literal infringement. But if we go back and look at our claim at column 4, in order to have literal infringement, that product has to meet each of the elements of the claim. And that's called the all elements rule. And it's fairly straightforward. So if we go back to claim 1, you would actually have to have a product out there that had a first scissor member, just like this, having the blade, second scissor member pivotally connected to the first scissor member. We've got that too. But then we've got a whole bunch of other things. The second scissor member having a sharp claw near its distal end, and so on and so forth. So this pair of scissors would not read on claim 1 of this lovely, unique scissor patent. That's literal infringement. There's also another alternative, which is the doctrine of equivalence, which really just simply means, you know what, it doesn't really infringe, but instead of a screw, they've used a nail. Instead of this, they've used that, and really, for all practical purposes, it's the same thing. It really infringes on the spirit of this claim, and with respect to every element as well. That's doctrine of equivalence. Then there is also contributory infringement and inducement to infringe. Those are doctrines which, the principles of them are pretty easy to understand. It's easy to see how contributory infringement would work. You perhaps supply one part of a product, someone else puts it together, and together you infringe. Or inducement, you are encouraging someone else to infringe your patent. And then willful infringement. Under the patent code, if a party is found to willfully infringe, knows about the patent, acts in reckless disregard of the patent, infringes that patent, then there's the possibility for enhanced damages. Willful infringement comes up in a lot of patent cases, and it's something to be very mindful of. It can make a case that's pretty small look a lot bigger because you can get up to triple your damages. All right, so if you have the litigation, here are the stages of litigation. This is what this looks like. First thing that happens is somebody files a complaint. Says upon information and belief, so-and-so has this product, I have this patent, and they infringe, and please give me money, and please shut them down. That's pretty much how that works. Then there's an answer, the person that responds, and then what happens from there is the court will put together a case management plan, which will map out then for about 2 years exactly how you're going to go from the initial stages of that litigation all the way through trial. Now, this can be kind of expensive, but before you get too scared, rest assured that actually, I read this recently, only about 5% of patent cases actually ever go to trial. So really the most likely thing that's going to happen is that somewhere along the way here, somebody's going to flinch, or both parties are going to get nervous, or they're just going to realize it's a whole lot nicer to get along, and they'll settle it. There are many stages of litigation that are set up to do just that. Assuming not, going through these stages, after you get through the case management stage, the initial pleadings, then you launch into something called discovery. Have you all heard about discovery? Okay. As far as I know, I've actually never met a person who likes discovery. I think I can say that. No one likes discovery. And there actually might be a couple of lawyers who like discovery. But generally speaking, no one likes discovery. This is the process where you actually sort of have to bare your soul to your opponent. And this goes both ways. We're sort of now in being the plaintiff, being the one whose patents infringe. But when you bring a claim, it's a two-way street. So you have to bare your soul to the defendant. It goes the other way around as well. And this happens in three primary ways. There's some other ways too, but the three primary ways. So one is document production, where you exchange all your documents to each other. Lawyers try to put protections in place. We draft protective orders. We try to limit the scope and so on and so forth. But generally speaking, you bare your souls to each other. Then we have something called depositions, which are actually very useful. This is the one opportunity to ask that nasty infringer, just, how is it that you think you could make this product in view of my patent? So you have your lawyer go in, ask a series of questions of the other side directly. And it's about the only time that you actually, through your lawyer, directly can ask the other side questions without all of those questions going through a lawyer. So everyone sits in a room together, lawyer's there, asks questions of the other side. And you can sit there and pass notes and tell them to ask this question and tell them to ask that question and so on and so forth. And then interrogatories, those are written questions that both sides will serve on each other. They're a little less useful because they flow through lawyers, and we cut back to the extent we can. We have lots of restrictions, and we barely ever give answers. From there, you have expert discovery. Expert discovery, you might need an expert with respect to the damages, how you've been harmed by the other side's activities. You might need an expert on the technology because it might be too complicated for the jury to understand or the judge. Those are a couple of things that are typically come up in patent cases. Markman proceedings, have you all heard of Markman? Wow, you're fairly educated, fairly savvy. Markman proceedings is something that has come into play for about, I guess it's been close to 2 decades now. It was decided at some point that really what this patent means, the claims, what they mean, is a matter of law. Just like a contract is a legal document and a judge should decide as a matter of law what that contract means, the same is true for a patent. It's a legal document, therefore the court should decide what the terms mean. And so there's actually a separate proceeding where the parties say, here are the claim terms that we need you, court, to take a look at and decide what they mean. Now you can imagine how this works. If I'm the infringer, then I want a reading of those words that's going to set me free, relieve me of infringement. If I'm a plaintiff, I want those words to be construed so that the defendant's product is going to most definitely fall within the scope of my claims. And believe it or not, well, you probably will believe it, we fight very, very hard over these words. And it's not all just show. For example, something like the word remote can mean very different things depending on the context, right? If it's a computer and I want to work remotely, I probably don't want to just walk outside those doors and work in the hallway. I probably want to be someplace like home. If, on the other hand, I want to monitor a patient in the hospital, remotely probably means I'm not standing there at the bedside. So these really are bona fide disputes about what particular words mean in the context of a patent. Then there's summary judgment, which is the opportunity to submit to the court issues that you believe the jury doesn't have to resolve. Things like, is the patent valid or invalid? Things like, is there really infringement? Those are the sorts of things you can submit to the court and ask the court to decide. And by the way, I should say, once you get the value of Markman, I mean, it's difficult because it adds a whole new phase into patent litigation, which is already notorious for being a pretty painful process. But what it can do on the positive side is it can actually tell you pretty clearly, do I infringe, or do I not infringe? Do they infringe, do they not infringe? And sometimes that can prompt a settlement. And then lastly, we have trial. And typically, patent litigation these days is going to take a minimum of about 2 years from start to finish. So it's kind of a long haul. But again, there are many opportunities along the way to settle the case. So that's litigation, or at least one side of it. no less than a reasonable royalty. A patentee, if there's infringement, is always entitled then to a reasonable royalty. Lost profits is a much harder standard. It's not always the biggest measure of damages, but sometimes it's quite substantial. And essentially what that is, in order to get lost profits, which means you're going to get the profits of it's really going to be as if you had sold the product yourself. And what you have to prove then in that instance is that but for the infringement of the defendant, you would have made all of their sales. And one way this comes up is really if for some reason the patent has been copied, and you know there was a patent, I had that exclusive territory, another person came into the market, they started selling something that was very, very close, and I see my sales just, theirs go up and then mine go down, and it really, it measures up just like this. That doesn't happen a lot, but when it does, lost profits is the measure of damages. And damages can be fairly substantial these days. As expensive as litigation is, it's often worth the effort because the damages are pretty high. So, how's that for a vague term? Another option, which you might be interested in, that's worth considering is licensing, obviously, as well. That's often also another result of what comes out through this process is the parties decide to get together and just license the technology. It's obviously also a good way to get the value for your patent. Now, the hazards of litigation I'm going to touch on when we get to defense, because you can't obviously engage in this process and put your patent out there and say you infringed without expecting the other side to come back and say, oh, guess what, your patent's invalid. You put your patent on the line, you subject it to increased scrutiny when you decide you want to enforce it. So you have to know that going into litigation that there are risks involved in it. And as I said along the way though, settlement is an option that comes up at many times, and again, most people settle. Usually the eve of trial, we litigators, we get all ready to go to trial, and then at 10 p.m., the night before trial, they settle and we go home. Right, Brad?
That's right.
All right, finally, just patent marking, just a note. This is really totally a side note. It's another way that you need to be thinking of too. If you have a product and you have a patent, that you're protecting your IP. Patented products under the patent statute are supposed to be marked. And you can mark it on the product itself. If it's not feasible, if your product is like this little, then you can mark it on the packaging. So it's not an absolute requirement, but they should be marked. The reason that this is important is if you don't mark it and you actually want to sue someone for infringement, you don't get any pre-filing damages for that. And you can think about what the rationale for this is. It's pretty straightforward. You have to tell the world you have a patent. And if you don't tell the world you have a patent, then how would they know? So, you won't get damages for that. So, have a product and have a patent market if you can. All right, let's go to defense. Freedom to operate. What is freedom to operate? I would probably get in trouble for saying this, but I will say it. In my just a general matter, I think you really never absolutely have freedom to operate. I think we all have to kind of just always be a little nervous out there. But generally speaking, what freedom to because you're in the business, and you might not think you infringe a patent, and that won't stop your competitor from suing you anyway. It's a bit of a fact of life that you have to know about. It also is only as good as that very day. And so it's something that you have to continually be on top of. The other thing is it's obviously only as good as the person who performed the search. It's really, really hard to get a perfect freedom to operate search of everything out there and whether you stay clear of it. So you have to know that. Integration into the development process. I mention that here again because just as a general matter, nobody really wants to infringe a patent. So they start off with a design, they get their freedom to operate analysis, and what happens is it comes back and everyone says, oh fine, just the design you have, here it is today, looks perfect, wonderful, go forward. Then as time goes by, they know about this other patent out here, it's a really great invention, and this, every day, starts to look a little more like this. And at the end of the day, you have a freedom to operate analysis, which was based on a product that then changed in the development process and actually morphed into an infringing product. That happens, and despite people's best intentions. So again, it needs to be up to date from a what is out there perspective. It also needs to be up to date from a what am I planning to do perspective, because development designs change. And then, as I mentioned before, this really should be a legal analysis, because it is a legal analysis, whether you infringe somebody else's patent. All right, if you end up being concerned about the competition, there are some things that you can do. First of all, just as a practical matter, obviously once you find a patent could go abandoned. Someone could fail to pay the fees. Patent term could have run. You need to have someone who's skilled enough to really be able to do the analysis if the patent is enforced. Obviously, again, it's a case-by-case, it's a country-by-country analysis too. So if you see a patent in Japan and you're not planning to sell in Japan, then that's fine too. So again, you're not immediately dead in the water if you find a patent out there. You need to check those boxes and make sure that some of these minimum requirements are met. But a lot of times there is really a design around out there that you can come up with. So you can try to design around the patent. That's one way to relieve your concerns about the competition. Another option is to work on licensing and cross-licensing. The only issue that you have to really tread lightly with is it's sometimes difficult to go to the other side and say, gosh, I'm sort of thinking I might need your technology for my product. And there you've sort of admitted infringement along the way. So if you actually do want to get into a licensing and cross-licensing arrangement with a competitor, it might be a good idea to have a lawyer brought into that process to make sure that you don't give away too much in those negotiations. Another thing people often do is come up with an opinion of counsel that gives them some security, relieves them of some of the concerns that they have going forward. Attorneys sometimes find creative and very solid non-infringement positions that you can have articulated for you and that can give you the comfort that you want, that you need to move forward. Less desirable, but certainly also a possibility is to have an invalidity opinion where the lawyer says, listen, the other patent is invalid, so I think even if we would find infringement, likely the patent would be found invalid. Now remember, the patent always, once a patent is issued, it carries a presumption of validity. So having a non-infringement opinion is much better than having an invalidity opinion. All right, if you get sued anyway, what do you say? Okay, first and foremost, always your best defense is I don't infringe. You can usually come up with a pretty good non-infringement argument. I've been surprised over the years. There's some pretty creative ways to argue that you don't infringe, even if initially you were concerned. Second argument, patent is invalid. We saw those statutes, all the requirements for patentability in the first instance. Later they come back and get you. All of the requirements now, the one who sued you says you don't meet. This existed before, it's anticipated by the prior art, it's obvious over the prior art, or some of the section 112 requirements, written description, best mode, what is required to be set forth in the specification isn't there. So those are the defenses. Another defense that comes up right a bit is if the patent was procured by fraud. And this sounds really harsh. You engaged in fraud on the Patent Office. These claims, I think the Federal Circuit a few years ago called these claims actually a plague to the system. And in a way that's right. The Federal Circuit hasn't backed off at all because there's still a lot of claims of fraud, but there are many, many claims of fraud. So what you say is basically there was something that you should have disclosed to the Patent Office that was important to whether this would be patentable or not. And you engaged in inequitable conduct, and therefore your patent is unenforceable. A little different from invalidity, it's unenforceable. Because just as an equitable matter, you shouldn't be allowed to enforce a patent that was procured by fraud. So that is another defense to patent infringement. There are many, many more. Things like, you waited too long to sue me. I actually invented this first. I actually invented this with you. Gosh, I think actually these are interfering. I have a patent. I think it interferes with yours. Let's see who really belongs, who really owns that technology. So there are many, many other defenses out there to raise. But again, those are just a few of them. And obviously, this litigation looks exactly like what I outlined to you before. We have our discovery, and we have claim construction, and summary judgment, and trial. Gosh, I think that's it. That's what my slide tells me. Answer fraud.
I think we have some time for questions. Some questions. We have good chance.
Sure.
Is there certain ways or certain cautions that you would share with us about how to talk about patent or patent infringement issues or workarounds in email?
Yes. I know that it is a reality. Okay. I'm going to tell you what would be my ideal scenario, and then I'll tell you some other things. The ideal is that the more often you somehow link a lawyer into that process, the better. Clearly, technical people have a lot of capabilities, a lot of skill in identifying patents they should be worried about or not. But if the technical analyses are made without a lawyer, there's no way for a lawyer, if you're in litigation, to shield those communications. They just won't be protected. And people say things that later end up being very different. Not through any fault, it's just the facts change, your understanding of the technology changes. And so to the extent that it is all possible, you would want those analyses, those to have some lawyer copied on them. Even if you weren't really seeking that lawyer's input, just keep someone in the loop. So that would be the best scenario. If you don't have a lawyer, then you might want to try to keep those communications to a minimum and have a scenario, have a dedicated set time aside for having those discussions. And encourage people not to use things like, I think it infringes, and things that you know are really legal analyses really should be left to the lawyer. So, you can use a lot of your technical language and it'll have fewer implications than like, oh, I think it's obvious, or oh, I think it's anticipated, using all of the patent phrases. Then when we get up there and to defend that person in deposition, it's pretty hard for us to stop the question that says, do you think that this piece of prior art anticipates your patent? And we go, objection, calls for a legal conclusion. Like, well, in his email right here, he used the word anticipate. I'm just using the witness's own words. So does that? Oh, okay.
So to clarify, so when you're looking to try and help prevent something from becoming discoverable later, CC
Yes.
your attorney. So is it then protected under attorney-client privilege?
Yes.
Is that how it works?
Yes. Yeah.
A question.
Yes.
So assuming you do find a patent maybe that you think your product is, and this is maybe even on the lines, that maybe you want to license, how best do you go about approaching the owner of that patent and that, without sort of admitting that you're infringing, but also to start the conversation that maybe you'd be willing to take a license to it?
I think there are a couple of different ways to do that. One way to do that is to have a very general discussion with someone in the context of, what are you working on? What do you have? Tell me about this, tell me about that. Because sometimes when you keep it in a more general context, it's not, I have this product and I'm worried that I'm worried that we infringe it. It's just a general communication about, let's explore some licensing opportunities together. If there's really a particular piece of technology that you're interested in, then I guess the other way to do it would be to ask whether they would have any interest in licensing that technology, keeping out the fact that there's a product somewhere in the wings, and just trying to make an inquiry from a general perspective about whether they'd be interested in that technology. You still kind of have the problem, though, that if they say no, and then you come out with your product, you're sort of, putting a little target on yourself. Gosh, they wanted the technology, they recognized they needed the technology, and they moved forward anyway. So it's a bit of a minefield.
So be careful.
Be careful.
Okay.
Yeah, and that was why at that juncture I also said that might be a time where you would want to, and again, I know that lots of small companies don't have the resources always to constantly rely on lawyers, but that might be the time where you have, you ask the lawyer, how can I do this without getting myself in trouble? Yes, Brian.
I have two questions.
And by the way, he's the prosecutor. If you want to know prosecution strategies and what the best claims look like and stuff, he's your guy.
Okay. Talk a little bit about the degree of due diligence you have to perform in order to file a complaint. This kind of goes to the method claims. You don't have to, I know that you're practicing every step of my method in your laboratory. You don't have to know that to file a complaint, but what do you have to know? Did you already talk about that?
No. It really depends on, it depends on the claims and what the product is. Sometimes, if you will, there's very little due diligence necessary because you have the product and you have it right in front of you, right? It would be this example. I have a product in front of me, I have a claim, and I can just look at it. And then I say, okay, technical people, do you agree? And they say yes, and we're done. That's the simple case. There are gradations of that. Your worst case is where you actually have, let's just say it's a chemical process. And once the chemical process is performed, basically everything goes poof, and you have no idea whether the chemical process, now that we're at this point, ever was engaged in somewhere at step 3, and now we're back at step 6. In that case, you can try to make as many inferences as you want, and the Federal Circuit has said at a certain point, if you can't know anymore, you are permitted to bring a patent suit, and then seek the discovery and be able to confirm one way or not whether they've infringed. But you want to try to do everything you can possibly to figure out what the process is in order to bring the claim. Because what happens is if you bring the claim and you have something like that extreme scenario that I just described, the other side, because we use all the tools of litigation that are at our disposal, is really going to accuse you of having violated what's called Rule 11, your duty of good faith. You brought a claim and you didn't have the basis for that claim set forth in the complaint. And so pretty much any time you bring a patent claim without knowing exactly what the other side is doing, you open yourself up to this accusation, which is fairly serious. Even lawyers don't like to be accused of Rule 11 violations. So the short answer to Brad's question is that you do everything you can your power to have as much information about what the defendant is doing as possible before you sue. Recognizing that at a certain point, you may simply run out of the ability to figure out what it is they're doing and have to sue in order to figure that out. And then there's some other strategy decisions you can make to try to get them to cough up some early information so that the parties can go, either go forward or, bail quickly. Yes?
Do you have engineers working with you to do the patent search? Because I know generally an attorney can't necessarily look at drawing and know whether or not it's an infringement. So do you have a science background?
Yeah, I do not. And when I say an attorney, it's a good question, because what I really mean is an attorney who also can understand the technology. So we're really lucky at Barnes & Thornburg, and different firms have different capabilities. But we have a whole group that just focuses on litigation, and a whole group that's very, very skilled in various technologies. So you're absolutely right. You want an attorney to do that analysis, but you also want them to have the technical background as well. And we, in our litigation group, have a mix of people who are technical and non-technical, recognizing that the jury's not technical, and so we sort of have our resident, the resident, I hate to use this word, but resident dummies. I just put myself in that camp. Who, if you can explain it to me, I can get it. I can explain it to the judge. I can explain it to the jury. Yeah. Yes.
I'm aware of all.
Yes. Sure.
I believe this is in relationship to a couple questions ago when you're talking about a chemical process that would be done and proof, and then you have a byproduct, and you're potentially selling a byproduct. Now with the scissor issue, you have this patent on these scissors. I'm not necessarily going to manufacture scissors and resell scissors, but I'm going to cut little Easter bunnies on paper and sell the little Easter bunnies, okay? If I go out and design my own scissors for my own manufacturing method, am I infringing the person who owns that scissor patent?
So the question is, or let me just make sure I understand the scenario. You manufacture a pair of scissors, just one pair, so that you can cut bunnies, is that right?
Yeah, I'm just using that as an example, so it's a little bit more layman terms, that's correct. So if somebody has a patent for these scissors, I don't want to necessarily purchase these scissors. I go ahead and design my own scissors to do my own cutting of paper, and I'm then selling the cut paper.
Yeah, and the answer to your question is yes, you are infringing the patent. You infringe someone else's patent when you make, use, sell, or offer to sell that product, an infringing product. So if you make a pair of scissors and it infringes somebody's patent, you have violated, you've run afoul of the patent statute. Now, that's the practical, or excuse me, that's the technical answer. The practical answer is that maybe no one will care because you didn't actually sell a pair of scissors, and there may not be many damages that come forth as a result of that. Now, the corollary issue will be if somehow those scissors add some extra value to those paper bunnies that you've cut, and that then is a much more difficult analysis. But the very basic answer to that is yes, you violated the statute, but it might not matter.
And when you say, because it all comes down to the damages, so if I'm not selling the scissors, it may be that I just made 10 pair of these scissors for my own manufacturing process, so I owe them profits on 10 scissors.
It might be. I mean, there might be larger consequences to it, but that's not the typical scenario. The typical scenario is there's a product out there, and you gain some value by using that patent, which results in a product.
Thank you.
Yes?
When would you counsel an entrepreneur to have an FTO, freedom to operate opinion, if at all? Early, right out of the box, a little bit further closer to commercial embodiment? When would you say, okay, now it's time to do it? Sometimes, don't do it at all.
No, I would never counsel against. I would always counsel in favor of doing a freedom to operate opinion. I think you're only smarter if you do that. And there are oftentimes very easy ways to get around the intellectual property that's out there. And you don't want to miss something that has no practical significance for you and end up, you know, in a patent dispute. So I would always advise to have some sort of freedom to operate analysis done. I think the time to do that is probably as soon as you think you're close to something that you have a preliminary design that is starting to take shape. Ideally, that's the time that you would do that, because your freedom to operate opinion would actually inform where you go from there. Again, recognizing that you would need to follow up as well to make sure that you didn't, in redesigning it somewhere along the way, you didn't end up running into someone else's patents.
Now, as a follow-up, is there any caution in sharing that freedom to operate opinion with investors, with potential partners, anyone that you might want to not see that? I mean, because there's probably not a lot of concrete language, even in an opinion.
Yes, that's a great question, and I'm sorry it's not part of my presentation. It may become part of my presentation. Anytime you have a legal analysis performed, you want to be very, 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 very cautious in sharing it with anyone. Lawyers, to the extent especially a lawyer's involved, we tend to be very, very candid, and you need someone to be candid with you. And the reason we tend to be so candid is because we know about that attorney-client privilege. And so I hope we will tell you again and again and again, this is attorney-client privilege, and please don't share it. Now, there are circumstances where you may decide you absolutely want to share it, and that's possible. But as a general matter, those have attorney-client privilege communications, and it's your candid analysis, and you don't want it to go anywhere outside of your company. And in fact, within the company, you want to restrict the number of people who have access to it, because you know what happens when the net starts getting cast too wide.
Would you advise doing, if you have to share it with an investor, would you advise doing it under a confidentiality agreement?
Yes. Yes.
Does that afford any protection in discovery?
Yes, it should. It should. It depends a little bit on the circumstances, but generally speaking, that would probably be enough to shield it in discovery. And I mean, all of these things, again, the attorney-client privilege communications, those never get shared, except under rare circumstances. And when you decide to share those don't get shared in discovery. We get really nervous about disclosing attorney-client privilege communications. Lawyers we hate that.
So basically, if you disclose that FTO to your investor or whoever, that would waive your attorney-client privilege, and they would be privy to any information that you.
Yeah, when you break the attorney-client privilege by disclosing that to a third party, that's how you do that. There are exceptions to that, and a confidentiality agreement is, if it's done properly, is probably enough to protect you in that instance. But as a general matter, as soon as you give it to a third party, you've just given it to the world.
So in that case, is it advisable to maybe have an FTO done by another firm that would not be your primary counsel? If it's really required by an investor and a confidentiality agreement is included?
No, I'm not sure I follow your logic on that one. You mean a counsel other than the one who's handling the transaction?
Correct.
The merger or whatever?
Right.
Well, as a practical matter, it would probably be someone different anyway. Maybe. I'm not sure it matters.
Okay.
Well, if there are no further questions, please join me in thanking Deborah for her presentation. And also, as sort of a closing remark, just want to say to those of you who aren't familiar with us within the foundation, we're the Office of Technology Commercialization. We handle all the intellectual property that comes out of the university. We are a resource to you, to not only you here, but also you in our remote locations and our partner companies. We have half a dozen licensing professionals on staff, and we can give you free advice, although free advice is often worth what you pay for it. The first advice we give you is to get a good attorney. They're certainly worth every penny you pay in these situations. Today I would like to recommend Barnes & Thornburg in Minneapolis. And it's with their support we bring you this forum. And so join me in thanking them again for such a good talk.